Yes, sir. Good evening, sir.
Good evening, Manish. Manish, introduce yourself.
Sir, my name is Manish Kumar Rathi.
Hmm.
I have been born and brought up in village Ghurkawas,
Hmm.
district Rewari, in the state of Haryana. I have done my schooling from the Rewari itself. After that, I pursued BSc from the University of Delhi, and after completing the BSc, I went for the degree of law from University of Delhi itself, and I completed it in the year of 2021. Thereafter, I started preparing for the Judicial Services Examination as well as simultaneously started practicing in the district courts of Rewari.
In the district courts of the Rewari.
Yes, sir.
This is your first attempt in Gujarat Judiciary?
Yes, sir. This is my first attempt.
और ये इस गुजरात जुडिशरी गुजरात के अलावा आपने कहीं किसी और स्टेट का भी एग्जाम दिया है?
यस सर, मैंने बाकी स्टेट्स में भी दिया है। जैसे मैंने हरियाणा का भी दिया है, दिल्ली में भी ट्राई किया है, एंड राजस्थान भी दिया है। इवन मैंने छत्तीसगढ़ एंड झारखंड भी दिया है, एंड
हम्म।
हिमाचल भी दिया है। ये
हम्म।
सभी मैंने और ट्राई किए हैं।
अच्छा, चलिए ठीक है। लेट्स सपोज
यस सर।
आप बताइएगा कि आप हरियाणा से हैं, रेवाड़ी से हैं, तो लेट्स सपोज
यस
अ
सर।
डिक्री इज पास्ड बाय रेवाड़ी कोर्ट।
यस सर।
डिक्री इट मीन सिविल मैटर। अ डिक्री इज
यस सर।
पास्ड बाय रेवाड़ी सिविल कोर्ट। ठीक है।
यस सर।
But the property of the judgment debtor is
यस सर।
situated in Ahmedabad.
ओके सर।
Now, my question is, can the Rewari court attach the property which is situated in Ahmedabad?
नो सर, द रेवाड़ी कोर्ट does not has the power to attach the property that is not in its jurisdiction. For it,
Okay.
it has to, yes, transfer the matter of the execution proceedings to basically the court where the property is situated.
कोई स्पेसिफिक प्रोविजन आपको याद आ रहा है सीपीसी में?
Yes, sir.
प्लीज।
Section 46 of the Code of Civil Procedure relates to it, that is regarding precepts.
सेक्शन
46.
46 it deals with basically execution.
Yes, sir.
According to you, this specific problem comes under section 46 of the CPC.
Yes, sir. As per my knowledge, I think it will fall under Section 46. For it,
तो
a precept has to be issued.
ओके, चलिए। आपने गुजरात के लोकल माइनर लॉज भी पढ़े होंगे।
Yes, sir. मैंने थोड़ा हाँ बेसिक आइडिया लिया है। आई डोंट नो इट इन डिटेल, बट यस।
चलिए, कोई बात नहीं। आप हमें सिर्फ 4 गुजरात के लोकल माइनर लॉज के नाम बता दीजिए अलोंग विद द ईयर्स।
Okay, sir. So first one is Gujarat Prohibition Act. And sorry, sir, I could not recall the years right now, but I will find it out later. But the first one is Gujarat Prohibition Act. The second one is Gujarat Gambling Act, Prevention of Gambling in Gujarat Act. I think I am like uh, not taking the name properly here,
चलिए,
but
कोई बात नहीं,
it is
तीसरा।
related to gambling, yes, sir.
ओके।
And the third is Gujarat Court Fees Act, and the fourth one is I cannot recall it right now. The fourth,
चलिए, आपने
yes,
पढ़ा
sir.
होगा लट्ठा। हैव यू हर्ड द टर्म लट्ठा?
No, sir.
चलिए ठीक है। लेट्स सपोज अगेन सिचुएशन फ्रॉम द सीपीसी, कोड ऑफ सिविल प्रोसीजर।
Yes, sir.
Let's suppose if a US court, United States court, grant a
Yes,
divorce decree,
yes, sir.
ठीक है, to an Indian couple.
Yes, sir.
Basically, a decree is granted by the United States court.
Yes,
Is
sir.
this decree binding in India?
Yes, sir. As per the Code of Civil Procedure,
Hmm.
it is binding in the Court of India, and it can be executed in India. The Code of Civil Procedure also provides for some exceptions in the case where it is not binding, like if it is violation of principle of natural justice, or the court didn't enjoy the jurisdiction, so or the decree was obtained by fraud or collusion. So these are some provisions. Only in
Okay.
these cases, yes, sir.
कोई स्पेसिफिक प्रोविजन आपको याद है?
Yes, sir. Section 13 and Section 14 of the Code of Civil Procedure relates to it mainly.
ठीक है। आपने केस सुना है ऐसा बोमाई वर्सेस यूनियन ऑफ इंडिया?
Yes, sir. I have heard of it. Yes, sir.
हाँ, प्लीज प्लीज, वेरी ब्रीफ with relating to the SR Bombay versus Union of India.
Sorry, sir. I cannot recall what was held in it. So yes, sir. Sorry, I will
चलिए,
find it out later.
कोई
Yes,
बात
sir.
नहीं। थोड़ा कॉन्स्टिट्यूशन से आपसे पूछते हैं।
Yes, sir.
कॉन्स्टिट्यूशन के अंदर आप हमें बताइए, कहीं शॉर्ट टाइटल डिफाइंड है क्या? शॉर्ट टाइटल ऑफ द कॉन्स्टिट्यूशन।
Yes, sir. It is defined, and as far as I can remember, it is defined in Article 392 of the Indian Constitution, or it might be 395. I cannot recall it exactly, but it is somewhere under around 390 articles.
ओके, ठीक है।
Yes, sir.
कोई रिसेंट कॉन्स्टिट्यूशनल अमेंडमेंट आप बता सकते हैं? कॉन्स्टिट्यूशनल अमेंडमेंट, रिसेंट कॉन्स्टिट्यूशनल अमेंडमेंट।
Yes, sir. Recently, the constitution was amended to give reservations, 33% reservations to women in the legislations of state and in the parliament.
क्या है रिजर्वेशन? कौन सा नंबर का रिजर्वेशन, कौन से नंबर का अमेंडमेंट है, कुछ बता सकते हैं? और उसके
Uh,
बाद कॉन्स्टिट्यूशन में कौन कौन से आर्टिकल्स न्यूली ऐड किए गए थे?
sorry, sir, I cannot recall them exactly.
अमेंडमेंट नंबर रिकॉल कर सकते हैं?
Sir, I can make a guess, but I'm not sure about it. The guess is amendment number 106.
श्योर
Amendment
नहीं आप
Act.
इसके लिए हैं?
Yes, sir, I'm not sure. लेकिन I guess as far as my memory
चलिए, व्हाट
is
इज द
concerned.
बेसिक डिफरेंस बिटवीन आर्टिकल 32 एंड आर्टिकल 226? बेसिक डिफरेंस।
Sir, Article 32 of the Indian Constitution can be invoked uh, primarily for Supreme Court and for the imposition of fundamental rights when
ओके।
fundamental rights are violated, and whereas Article 226 is broader in nature and it can be invoked by the High Court.
Okay, then what is the basic difference between Article 226 and Article 227?
Sorry, sir, I'm not aware about it.
Okay. What do you mean by the term judicial restraint? Judicial restraint.
Yes, sir. So judicial restraint is somewhat opposite of judicial activism. So where the judiciary restrains itself from interpreting the legislation or from passing a law through its judgment. So that is where we can say that it is judicial restraint.
Okay. My next question, please listen
Yes, sir.
very carefully. Is the
Yes.
WhatsApp message constitute a document under Bharatiya Sakshi Adhiniyam? WhatsApp message.
Yes, sir. WhatsApp message will constitute a document as per the Bharatiya Sakshi Adhiniyam.
As per the Bharatiya Sakshi Adhiniyam.
Yes, sir.
आपको कोई कोई रेलेवेंट प्रोविजन याद आ रहे हैं?
Sir, Section 2 defines what is document. So,
What do you mean
uh,
by that term document under Bharatiya Sakshi Adhiniyam?
so document means that any matter which is expressed uh, in letters, symbols, or anything, and the main purpose of it is to record for recording it. So that is what
For
basically
the
a
purpose of
document is.
recording that matter.
Yes, sir.
And what is the basic difference between the definition of document under Bharatiya Sakshi Adhiniyam and under Bharatiya Nyaya Sanhita?
Under Bharatiya Sakshi Adhiniyam and Bharatiya Nyaya Sanhita.
Yes, the term document is defined under both these laws.
Yes, sir. Yes, sir.
What is the basic difference between them?
Sorry, sir. I cannot
चलिए, ठीक
recall
है।
it right now.
Who is the current Chief Justice of the Gujarat High Court?
Sir, it is Honorable Miss Justice Sunita Agrawal ji.
And who is the current Chief Justice of the Supreme Court of India?
Sir, it is Honorable Mr. Justice Suryakant ji.
Suryakant ji. Honorable
Yes,
Mr.
sir.
Justice Suryakant belongs to which state?
Sir, he belongs to the state of Haryana.
He belongs to the state of Haryana. Okay.
Yes, sir.
कौन से नंबर के वो चीफ जस्टिस हैं करंट इंडिया के?
Sir, he is the Chief Justice, 53rd Chief Justice of India.
53rd चीफ जस्टिस ऑफ इंडिया। उनसे पहले
Yes.
कौन चीफ जस्टिस थे और उनके बाद कौन चीफ जस्टिस बनेंगे?
सर, उनसे पहले Honorable Mr. Justice B.R. Gavai, and after him, the probable succession is of Honorable Mr. Justice Vikram Nath ji.
विक्रम नाथ जी।
Yes, sir.
Okay, what are the essential qualification to be appointed as judge of Supreme Court?
Sir, the qualifications are either he is an eminent jurist or he must be practicing in the court of in any high court for 10 years, or
Hmm.
he might be a high court judge for at least, as far as I can remember, I'm not sure about it, for 5 years, I guess. Or it
Five
might be
years.
10 years, yes, but I think it is
So
5 years.
according to you, he may be a distinguished jurist or second?
Eminent jurist, and then he should be an advocate of High Court, or he should be an High Court judge
Advocate of a high court for how many years?
for 10 years.
For 10 years. Okay.
Yes, sir.
Okay, fair enough. What is the basic difference between void and voidable marriage? Void and voidable marriage.
Yes, sir. Sir, void marriage is a marriage which is not a marriage in the eyes of law from the starting itself.
Okay.
Whereas voidable marriage is a marriage which can be repudiated by a party who is aggrieved by any of the term, basically like where the free consent is not there. So that falls under the category of voidable marriage.
चलिए ठीक है. What is the most challenging decision you have taken in your life?
My most challenging decision.
Most challenging
Uh,
decision.
yes, sir. So just give me 2 seconds to think.
Mhm.
Sir, I think my most challenging decision was to shift from science background to law itself was the most challenging decision and the most brave decision I can say that I took.
Okay.
Yes, sir.
चलिए ठीक है. Please explain why
Yes,
BNS भारतीय न्याय संहिता focuses
yes, sir.
on the victim centering approach.
Because
Very briefly.
as
Hmm.
yes, sir. Because as per BNS, or you can say Bharatiya Nyaya Samhita, the victim is also an important. A crime is wrong against the society itself, and the accused must be punished. But the society will get better if we take care of the victim and try to reform the accused as well. So that is why victim-centric approach is also primarily focused under Bharatiya Nyaya
Okay.
Samhita.
So according to you, victim may be either men or women.
Yes, sir.
It means it is gender neutral, BNS.
Yes, sir.
But
Yes, sir.
when we talk about section 63, that is rape, it is
Yes, sir.
gender specific.
Yes, sir.
Now, my question is section 63 of the BNS
Yes,
is
sir.
the violation of Article 15 of the Constitution?
No, sir. We cannot say so that Section 63 is the violation of Article 15 because uh, accepted that Article 15 says that everyone should be equal in the eyes of law. But
Hmm.
there are something like special provisions that it also allows special making of special provisions for women or child specifically. So it is absolutely not a violation of Section 15, Article 15.
Okay. चलिए
Yes,
ठीक है. Have you heard about the term doctrine of frustration under Indian Contract Act?
yes,
We just want only one case law and the specific section which deals with the doctrine of frustration.
yes. Sorry, sir, I cannot recall the exact case law. I'm not good at remembering the names, but yeah, the section that relates to the doctrine of frustration is Section 56 of the Indian Contract
Section
Act.
56 of the Indian Contract Act year
Year, sir, 1872.
1872 deals with the Indian Contract Act
Yes, sir.
and 1882 deals with,
Sir, it deals with Negotiable Instruments Act.
and again 1872 also deals with
Sir, it used to deal with the Indian Evidence Act also.
Indian Evidence Act also.
Yes, sir.
Okay. CPC, BNSS, Indian Evidence Act, or we can say Bharatiya Nyaya Samhita, Bharatiya Sakshi Adhiniyam, Bharatiya Rajaswa Samhita is these are the part of union list, state list, or concurrent list?
So they are part of the concurrent list, both the state
Concurrent
and
list.
the, yes, sir.
Okay. So it means if any subject matter is governed under concurrent list, then
Then it can be amended by both the parliament
it
and
can
the
be
state
amended by
legislature,
both
the
parliament or
parliament and state legislature.
state legislature. Okay. And the subject matter, it means union list, state list, concurrent list is defined under which schedule of the constitution?
So they are defined in the Schedule 7 of the Indian Constitution.
Schedule 7. How many subjects are in union list?
Sorry, sir. I can make a guess, but I'm not sure about it.
Mhm.
Uh, I think around 50 subject matters are there in the union list.
50.
50, yes, sir. It is a, just a guess. I'm not, yeah, I'm
Okay.
not sure about it. Yes, sir.
Have you heard about doctrine of holding over?
Yes, sir. The
Please.
doctrine of holding over is given in the Indian Partnership Act, and it somewhat is similar to the doctrine of estoppel, in which if a partner represents himself as if a person who is not a partner represents himself as a partner to any third party,
Hmm.
then he can be made liable for the transaction.
ओके आप न्यूज़पेपर
Yes,
पढ़ते हैं
yes, sir. I try to like read it
रीड
whenever
इट
I get time. Yes,
ठीक
sir.
है
Yes,
ओके
sir.
प्लीज एक्सप्लेन
Yes, sir.
three biggest challenges India is facing right now.
So, in my opinion, one of the biggest challenges that India is facing is through its border disputes, mainly with Pakistan and China. And after that, one can say that the second issue can be said that India is highly populated, so a lot of schemes and the policies are like beneficial to some persons and detrimental to others. So it is also somewhat issue, but also a boon sometime. And the third I can say is third issue about India
चलिए कोई नहीं
is with America. One can say the relations over the past 1 year cannot be said to be going smooth. They are like,
चलिए
but they yeah transformed into a better since the trade deal is signed.
ओके ओके
Yes, sir.
section 10 specifically fact. Have you heard about section 10 of the specifically fact?
Yes, sir. But I
Section
cannot. Yes, sir. Sir, I think it makes the mandatory. It makes the relief of specific performance as a mandatory relief.
mandatory.
Yeah.
Okay.
Yes, sir.
Please, in a very brief way, what is the basic difference between rectification, recession, and cancellation under specifically fact? Basic difference in one or two line.
So the cancellation and the rectification is done of an instrument, whereas recession is done of a contract. And cancellation is basically means that the instrument is cancelled.
Hmm.
And yeah, and the rectification of instrument basically means to correct any bona fide mistakes on the part of both the parties
अच्छा.
through it. And the rescission of contract is when the contract is voidable, then the aggrieved party can approach the court for its rescission, basically for taking back the contract, for cancelling it.
Okay.
Yes, sir.
Have you heard about section 18 to 22 of the Domestic Violence Act? 18 to 22.
Yes, sir.
Please explain section 18 to 22. Only heading 18 deals with, 19 deals with, 20 deals with, please.
Yes, sir. So Section 18 of the Domestic Violence Act deals with the relief of protection order, and Section 19 deals with the relief of monetary order. Section 20 deals with the relief of residential order, and Section 21 deals with the relief of compensatory order, and Section 22 deals with the relief of custody order.
Custody order. चलिए ठीक है.
Yes, sir.
According to you, what is condolation of delay under Limitation Act? Condolation of delay.
Yes, Section 5 of the Limitation Act deals with the condonation of delay. It basically applies in the cases of appeals and applications, and where a party doesn't prefer an application or an appeal within the time specified prescribed period, then if the party was prevented by some sufficient cause, then the court can condone the delay.
Court can condone the delay
Yeah,
according to
and
what is
allow.
required under Section 5.
Yes, sir.
चलिए ठीक है. My next question is again from the Constitution.
Yes, sir.
What is the basic difference between due process of law and process established by law? Basic difference.
Sorry, sir, I'm not aware about it.
Have you heard about the case EP Royappa? EP Royappa case versus State of Tamil Nadu?
Sir, I have, yes, malab heard about it, but I have not gone through it. I cannot recall it right now.
Okay.
Yes, sir.
चलिए ठीक है. Let's suppose you are a judge
Yes, sir.
and you recognize a lawyer appearing before you as a close personal friend from your law school.
Yes, sir.
Okay. What do you do in these circumstances?
Sir, in these circumstances, I will not be biased towards it, towards him. And yes, sir, since I have graduated from University of Delhi and it is a various student study there, so there are high chances that I will get to meet such people during my tenure. So I will try to not to be biased at all towards any advocate such nature. And if he is appearing as a party, then I can ask to be recused from hearing that case.
किसको बोलेंगे आप इस चीज के लिए?
From the chief judicial magistrate.
Okay.
Yes, sir.
My few questions. One of my question is, why
Yes.
is physical fitness important for a judge? Physical fitness.
So physical fitness is not the most important thing for being a judge, but a physically fit person can have less health issues. So it can be beneficial that he can sit for long. Otherwise, it is not such a major issue if a person can conduct himself very well for long hours and sit.
Okay. My next question. Let's suppose you are a judge and in your courtroom, a witness turns hostile.
Yes.
ठीक है? Is their entire testimony discarded?
Sorry, sir, I couldn't hear your later part of the question.
The entire testimony of that hostile witness, whether the entire testimony of the hostile witness discarded, rejected, not admissible.
Yes, sir. No, sir, it is not necessary to discard the entire testimony of the hostile witness. We can also look for the circumstantial evidence that are for completing the chain. And if something is corroborating that chain of circumstantial evidence, and if it is appearing to be reliable and trustworthy, then it can be included. It is not necessary.
अच्छा, चलिए ठीक है.
Yes.
एक क्वेश्चन और बताइए. Let's suppose you are a judge.
हाँ जी.
You are a judge or magistrate, and the police bring an accused for remand at around 1 a.m. at midnight at your residence.
Yes, sir.
Okay. They claim urgency.
Yes, sir.
But the papers are incomplete. The papers which is provided by the police are incomplete. What is your immediate course of action in these circumstances? Police is appeared at your residence with incomplete paper at around 1 a.m. Okay, please explain what is your course of action in these circumstances.
In my opinion, मैं उनको कस्टडी, अगर वहां पे अर्जेंसी है और कस्टडी देने की जरूरत भी है तो
हम्म
कस्टडी के लिए अलाउ कर दूंगा,
हम्म
लेकिन जो इनकम्प्लीट पेपर्स होंगे उनको भी जल्दी से जल्दी पूरा करने के लिए बोलूंगा विद इन दैट डे इटसेल्फ।
तो मतलब बिना प्रॉपर पेपर के आप कस्टडी ग्रांट कर देंगे, रिमांड ग्रांट कर देंगे?
So for few hours, yes, sir, it can be granted as the matter is urgent. If it is really urgent, then I think it can be given, because it is basically a procedural defect, and procedure is the handmaid of justice, not its mistress. So following that principle, uh, uh, थोड़ी बहुत लिबर्टी मिल जानी चाहिए इन माय
चलिए, एनआई
ओपिनियन।
एक्ट पढ़ा है आपने, नेगोशिएबल इंस्ट्रूमेंट एक्ट?
यस सर।
प्लीज एक्सप्लेन व्हाट इज द बेसिक डिफरेंस बिटवीन सेक्शन 143A एंड सेक्शन 148?
सॉरी सर, आई एम नॉट अवेयर अबाउट इट।
Section 143A, have you heard about Section 143A?
Sir, I couldn't recall exactly what it talks about. Like I know the concept, but not regarding the
Have you heard
exact.
about India United European Union trade deal?
Yes, sir.
The reporters called it mother of all deals.
Yes, sir.
Why this deal is treated as a mother of all deals?
Sir, because first of all, the deal, India was trying, India and both European Union was trying to struck the deal since a long period, around
Hmm.
from the past 8 9 years they were trying, but the negotiations were not going through, and now the negotiations have went through, and India, like a major chunk of exports from India and from European Union also will be like freely manageable through that trade
Hmm.
deal that were now. So it will be beneficial for both India and European Union, but India was also trying to stuck it. And the main issue was with some automobiles company, and but that is now been resolved. So that is why.
Okay,
So yeah.
ठीक है. My next question is, please mention only three judgments of the Supreme Court of the year 2025. But according to you, these judgments must be landmark judgments in their
Yes.
respective fields. Only three judgments of the Supreme Court.
Yes, sir. So the first judgment that I would like to mention is with regard to Amlesh Kumar judgment,
Hmm.
and that is basically related to the DNA, or the allowing the narco analysis test on the basis of the accused. If the accused demands it, then whether it should be allowed or
Yeah.
not.
It is first.
And
Second.
second one is related to the Aravali judgment case. I cannot recall the exact name of it, but in that the Honorable Supreme Court of India defined the what can be included in the Aravali, in the
Hmm.
definition of Aravali Hills. And the third judgment that I would like to call it is regarding the 3 year experience rule that was like established by the Honorable Supreme Court of India for appearing for the civil judges post.
क्या
So
नाम था
these,
इस केस का?
sir, I'm not sure about it, but it was something on the lines of All India Judges Association versus Union of India, like a little bit. I may be wrong in this case. Yes, sir.
चलिए ठीक है. गुजरात हाई कोर्ट के स्पेसिफिक जजमेंट्स आपको पता है? नेम एनी वन सिंगल जजमेंट ऑफ द गुजरात हाई कोर्ट which
Sir,
was the landmark judgment in the year of 2025. Only one.
yes, sir. In the year 2025, I am not aware, but recently
Hmm.
the Honorable High Court of Gujarat acquitted three accused of rape in the case of State versus Gopi. So that was, yeah, a huge case that was on the basis of like not completing of the chain of circumstantial evidence.
What do you mean by circumstantial evidence?
So, there can be said to be two types of evidence: circumstantial evidence and direct evidence. So, direct evidence are which conclusively establishing the uh, guilt of the accused, like eyewitness is there who has himself seen the incident happening or the crime happening. But in circumstantial, the circumstances are present, not
Hmm.
any direct witness, but circumstances are pointing towards the guilt of the accused.
Okay, and
Yes,
what
sir.
is exceptions of the hearsay evidence?
Sir, hearsay evidence exceptions can be said like the rule of res gestae or the doctrine of dying declaration. So these can be included in its exceptions.
ठीक है. आज डेट क्या है?
Sir, today the date is 16th of February 2026.
16th of February
26.
2026. Okay.
Yes, sir.
Last question from my side.
Yes, sir.
Capital of Manipur. Capital of Manipur.
Sorry, sir, I cannot recall it right now.
इंडिया में कितने states हैं?
Sir, India has 28 states.
And how many union territories?
Sir, there are now 7 union territories.
7 union territories. There are now
Yes,
7
sir.
union territories. Earlier,
Yes, sir. Earlier there were 5.
5.
Yes, sir.
Okay. चलिए ठीक है. Okay, आपका इंटरव्यू कंप्लीट हो चुका है, मिस्टर
Thank
मनीष.
you, sir.